All persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Justice Meade. To my right is Justice Neyman, and to my left is Justice Hand. We'll be the judges on all 6 cases today. If you haven't been here before, welcome. You have been before here, welcome. Each side gets 15 minutes. We've read everything. My best advice is to get right to the point. With that, I'll call the first case 23P 762 Commonwealth versus Mr. KARWIEL. Mr. Sullivan.
Good morning, Your Honors. May it please the Court. My name is Ryan Sullivan. I represent Mr. KARWIEL. Your Honor, I'm going to take your advice and get right to the point. Mr. KARWIEL was denied effective assistance of counsel in this case. He was denied effective assistance of counsel most egregiously by the way he failed to admit, effectively seek to admit, ask for a trial when he was, asked for a continuance when he was...
Well, he did try, though. He tried to get the records in. The judge denied it.
The judge denied it because primarily based upon relevance grounds. And that was the problem, is that counsel wasn't able to effectively argue the fact that a person who had, in the preceding 10 years, had 2 separate surgeries relating to his mobility issues, has just gotten involved into a single motor vehicle crash, and had been receiving ongoing pain treatment, including the day of the arrest, earlier that day. Counsel was unable to convey why that might be relevant in front of the jury.
You know, I find it interesting or puzzling that you don't argue on appeal that the judge's exclusion of the records was an abuse of discretion.
So part of the reason I don't argue that it wasn't an abuse of discretion on appeal was because of the way in which counsel framed everything and resulted in the court indicating, although I disagree with her finding, that his rights weren't preserved in that matter. I think a proper remedy is for Mr. KARWIEL to get a new trial.
But to Judge Meade's question, wouldn't the records just in of themselves, the medical records, be relevant just simply to corroborate his statement that he had back or back injuries and surgeries? I think he said something to that effect at the scene. So wouldn't just the mere existence of records corroborate that statement and tend to be relevant on that basis, without an expert, without anything else?
I agree. I don't. So one of the points that the Commonwealth makes in arguing against this being ineffective is that I didn't present an affidavit of myself saying how they were relevant. In my belief, I don't believe that they are. I don't need it in order to convey this before a jury. For instance, a diabetic doesn't need to say, I need treatment that day to say I need my insulin. No, having the treatment before is sufficient. I agree with the court that they are relevant. They are admissible. One of the reasons the Commonwealth contends that trial counsel wasn't ineffective is because this relevant information about his mobility issues went through the jury in a different way. They were relevant. Counsel was unable to articulate, probably like I'm unable right now to articulate, that they were relevant. That was why he was denied effective assistance of counsel.
The judge was concerned too that the records weren't self-explanatory and could possibly lead to the jury speculating about what they meant because there was no expert to explain them.
Similarly, there was no expert to explain why the field sobriety test would relate to the fact that a person driving. It's because
but correct me if I'm wrong, you don't have an affidavit from an expert saying that could be done or that someone was available to do that.
That's correct that I don't have an affidavit doing that. It's my contention, if the court were to agree with me and find that it was an abuse of discretion for the court not to allow, for the trial court not to allow the motion for new trial, when I try Mr. KARWIEL's case, I'm going to be able to use those records and say, this person has...
But you have to bring something to the table for the trial and motion judge here who's entitled to special deference, having wearing both hats. So when one of those things would have been an affidavit from an expert.
So the issue that the trial court was having was saying that there was insufficient evidence to show that his mobility issues related to field sobriety tests. That's an incorrect assessment of what the particular issues are. It was a factor, the fact that he had these surgeries, the fact that he was in chronic pain, was a factor that the jury should have been able to consider when...
How old were the records?
They went from 2008, his first surgery, 2010, his second surgery.
So 8 to 10 years prior to the incident?
So those are when the surgeries took place. The records then continued for the remaining 8 years up until and including the day of arrest, where he continued to seek ongoing pain as a result of the issues. I can have to agree that the pain that he was seeing for that morning was related to tingling and feelings in his arms rather than his legs. So
He told Trooper Lloyd that he did have a back injury, and that it wouldn't prevent him from or affect his ability to take the field sobriety test. What do we do with that?
So that's another example of why, when counsel is framing the entire issue, he's missing the point. The trooper asks, do you have any injuries? He says yes, and he provides them. Would they have an ability for you to perform these, would they impact your ability to perform these tests? You know, the tests that I haven't yet explained to you what they are. And he says yes. That was what I mentioned in my brief of the lack.
This is his 5th OUI. I think he knows how a field sobriety test goes.
His prior 4 were separated by over 15 years from the date of the incident. And so I don't remember what I was doing 15 years ago, but I understand the court's point. But that is a point that he could have at least asked that. That was the lackluster cross-examination. The cross-examination was structured to say, this is a case where a person is disabled. No, this is a case where a person has mobility issues and is in constant pain. And when you're assessing the government's strongest piece of evidence, which is the field sobriety tests, the fact that he was in that pain, the fact that he had had surgeries with respect to his mobility issues, the fact that he continued to seek treatment during that period of time should have been a factor that the jury could consider. And the fact...
What was the date of the most recent record?
The date of that arrest. July 16th.
He had a medical, you had a medical record from the day he was arrested?
From the Anna Jocks Hospital, yes. That's when he first sought treatment for pain that morning.
But aren't those two different things, though? You're talking about the surgery on the one hand and the pain on the other. The surgery is remote in time, and there's no explanation provided as to what impact the surgery or the post-surgical status that your client had impacted his ability to complete the tests that were required. Is that correct?
It is correct that the surgery was from, the most recent surgery was 8 years removed from the date of the incident, that he had received ongoing treatment for the following 6 years directly related to that.
Okay, and the jury knew that at least that he had had back surgeries from another source, another piece of information, from his cousin?
Yes, they did, yes.
Okay, and we don't today on appeal, excuse me, have any information included in the new trial documentation that would show what how the surgery impacted your client's ability to perform field sobriety tests. Is that also true?
That is also true. And there are, in my mind, 2 reasons for that. One is that, as I contend, I don't think a medical expert was necessary for that. But 2 is because this is not a situation of Mr. KARWIEL had a prior back surgery. He was in pain. Therefore, I'm opining that he could not perform this test. That, I don't think, would satisfy the relevance test as to whether or not that is accepted by the scientific community. What I'm saying, though, is that that is a piece of evidence that counsel could have, and it's clear from his cross-examination, thought regarding how he was going to advance his defense of Mr. KARWIEL. That when you take that piece out and counsel continued with his presentation, his argument, his cross-examination without that piece and made no changes as a result of it, that is why he was denied effective assistance of counsel.
To the extent you are arguing that an expert was not necessary, how was counsel ineffective? Where did his proffer fall short?
When the court looks at the way in which he explained his answers to the judge on most notably the second day of trial, so the first day of testimony, counsel doesn't understand what the court is asking of him. The court is saying, you need an expert, and his response is, okay, well, then I'll just submit all of the medical records. That he didn't understand what the court's question was. He wasn't able to articulate it. And therefore, everyone here agrees that evidence regarding the fact of him having surgery would be a relevant inquiry. There was one person who was unable to convince a court that that was relevant, and it was trial counsel. That alone shows that he fell measurably below what is expected of an ordinary fallible attorney.
If we accept that as true, if we accept the proposition that if the first prong of Safarian is met, then with respect to the surgical portion, I'm still stuck on how we find prejudice when we don't know what your position is. No expert was needed.
Correct.
Okay. If we disagree with that, then can we find prejudice if we are of the view that an expert was needed to explain what the impact of the surgery was on your client's ability to?
I still think you can find prejudice in the way in which the trial commenced without that piece of evidence. The argument advanced by trial counsel was, this is a disabled person, these tests aren't made for disabled people. And that just misses the mark. I understand that the Commonwealth may respond to that statement that I made in opening and say, well, you know, this is not just a person who made a poor tactical decision. It's the problem is this person who doesn't show up in person for the final trial conference, shows up late when he's told to brief an issue, doesn't brief an issue, and then continues with his cross-examination and closing argument as if the records that he sought to admit were admitted. That's the problem. That's why he was prejudiced here, is because...
No, I understand your frustration. I see the basis for your frustration with the performance, but I'm not necessarily on board yet with your argument about prejudice on either side. I think with respect to the pain argument, given what the other evidence is, I just think you've got a lot of evidence supporting guilt and not a lot of evidence that would suggest that additional records indicating that your client was undergoing additional treatment for pain, including some of the potentially damaging information included in those records, would have been enough to sway the balance.
So I think that we have, so the government in their arguments is saying that they have 9 cold beers. Well, at the Anna Jakes Hospital showing that I believe it was 6 hours before his arrest that he was inside of that would demonstrate that there's a smaller window of time. That would have been helpful to frame the argument as to how much alcohol Mr. KARWIEL could have consumed that day. Counsel didn't even go down that road because the records didn't get admitted, and frankly, I don't think would have gone down that road because he was missing the point. The government talks about the smell of alcohol. Every person who's been convicted of an OUI, and all of my clients who've been acquitted of an OUI, have all smelled of alcohol. And then incoherent speech. I've been giving you incoherent speech all day. I assure you it has nothing to do with whether or not I've consumed any alcohol. The evidence
They are signs of impairment, though. Come on.
They are signs of impairment. I agree with you. But what I'm saying is...
He also crashed his car into a sign, and he was perpendicular to the flow of the road, too.
Correct, because of the way that he crashed the sign. So, for instance, he hit it on the right-hand side, so he was clearly drifting off the left, hit it, and continued to spin out that way. Why counsel didn't at any point in time bring up, hey, does difficulty with balance, does being incoherent, does having any of those problems associated with a concussion, why that wasn't asked is another example of why he was not entitled to the benefit of effective counsel. I agree that I did not raise in the motion for new trial or in my brief those issues. And the reason I didn't raise those issues is I can see bits and pieces of what I would have done differently than trial counsel. It is this glaring piece where he was not just given vague statements by the court, but he was chastised for his ill-preparedness related to the medical records. That is the perfect example of why this lawyer was not prepared for this trial and why my client's right to effective assistance of counsel was denied. It is that issue. Looking at the entire context, this would have been different had he had a different lawyer. And I think that we can see that most clearly in the way it was handled, the way it was failed to admit these records and the lack of any change as a result of that. If there's no other questions, I'd rest on my brief.
Okay, thank you very much. Ms. Cohen.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. The Commonwealth argues that the defendant is unable to meet his burden on either prong of Safarian. As to the first prong, Commonwealth, of course, argues there was no ineffective assistance of counsel here.
Can you bring that microphone
Oh, I
closer to you?
apologize, Your Honor. That's because there's no other argument that could have been made by trial counsel to make the records admissible absent an expert's testimony. The affidavit of trial counsel also indicates that not engaging an expert to admit the records was a tactical decision, and that was not an unreasonable decision given the circumstances of the case.
Is there any evidence to support the tactical decision argument? It seems that the counsel did, although I understand that that your colleague on the other side argues otherwise, but there was an effort to introduce those records. It wasn't a tactical decision not to introduce them.
I agree. I don't believe it was a tactical decision to not, I believe the tactical decision was to not engage an expert. I believe that counsel wanted to have the records admitted absent having to have a witness testify to get them in.
And what's your basis for saying that was a tactical decision versus an ignorant decision?
My basis for that is the affidavit. I think the counsel lays out what he didn't do in separate points, and I believe he says, I did not seek to retain a medical expert to explain the records. He doesn't say that this.
But how does that make it tactical?
Well, I think that the evidence of the case kind of shows that this was, I suppose my argument, it was reasonable to make that decision, and therefore it was a tactical decision. I would also say that there was testimony in the record that counsel, that either counsel or the defendant had spoken to the defendant's physician about admitting the medical records and that the physician disappeared. So I think there is some evidence that there was at least talk or consideration of having somebody come in to the trial to testify to get those records in, and that didn't happen. And again, I do think it was reasonable given the evidence outside of the field sobriety tests was pretty significant, and that
Well, that goes to prejudice.
yes, but I think it also does go to the reasonableness of a tactical decision, if there was a tactical decision. But I think even if the court disagrees and finds that the defendant has met his burden under the first prong, I would still argue that he can't meet his burden under the second prong because the back injury was presented to the jury, albeit not in as much detail, but it was before the jury, and it was put before the jury in a way that didn't invite questions such as, could a back injury have caused the defendant to smell like alcohol on the day? So I think
Right, but wouldn't the medical records have supported the defense?
they would have supported the defense,
They
yes.
would have been objective, they wouldn't be biased, they wouldn't be subject necessarily to credibility determinations, right?
But I believe, Your Honor, where there was nothing in the records connecting the back injury to any kind of mobility issues, that would have come in through the expert and.
Okay, but before we get to an expert,
Sure.
the trooper testifies at trial. I got him out of the car, I asked him to perform field sobriety tests, and I asked him whether you had any prior injuries or difficulties that would hinder or prevent you from doing or completing field sobriety tests.
Yes.
And he, the defendant, told me, yes, I had prior back surgeries and I had thoracic injuries.
Yes.
So wouldn't those medical records be relevant and admissible if for no other reason, just to corroborate what the defendant said at the scene, to show to the jury, hey, he wasn't lying about this, he had prior back surgeries and prior back injuries. Why is that not relevant, admissible evidence?
I think it is relevant because clearly there was an injury, but I think the records on their own don't indicate what that would have had to do with the defendant's ability to perform the test. So I think, yes, for
Wouldn't it at least be relevant to corroborate the defendant's statement at the scene?
sure, but I think absent an expert, that isn't entirely clear to a layperson on a jury. I think the records are extremely technical and difficult for anybody to understand. So it's, although there's some kind of injury, and yes, it would probably be corroborative, I think that it does little more than that. And I would also say that you have corroboration in this case anyhow because you have the trooper testifying to the fact that the defendant said he had a back injury, and then you have
But without the medical
cousin.
records, the jury could just say, okay, he was lying and making excuses to the trooper because he was drunk.
But I think, Your Honor, then we have the defendant's witness, his cousin, corroborating that there was a surgery. So I think there was enough there for the jury to say he had a back surgery or he had a back injury. And again, I would argue that it put the issue before the jury without any other damaging inquiry into how that injury would have affected his abilities. If there are no further questions.
Seeing none, thank you. Thank you both.
Thank you, Your Honor.
Our next case is 23P601, Commonwealth versus LINENKEMPER. Mr. Rubin.
Good morning, may it please the court. I'm Eric Rubin and I represent Matthew LINENKEMPER in his appeal. I just wanted to thank the court for their kindness in continuing this matter as a result of my wife's illness, and I want to especially thank my brother for his kindness as well. The court below abused her discretion in allowing the Commonwealth's motion to introduce the prior bad acts. Prior bad acts are generally inadmissible unless they're probative, and there's very specific language through the Creighton case as to what would make them allowable or admissible, excuse me. But here, the judge herself said they weren't relevant. She said it on the record. So that already is problematic.
But was that a finding about about the relevancy of the records, or was that maybe an overly broad way of explaining the fact that the records were relevant for only limited purposes?
Well, and I understand that as an attorney, and of course, Your Honor, as a justice of this court, but we have a panel of, it's a double-edged sword to call them lay people or non-lawyers, but we have non-lawyers in the jury box. And in some ways they're sophisticated, and in other ways they're not. And the rules of evidence have not been studied by most of them.
Okay, but then I'm sorry to interrupt you, but if you're getting to the point of saying the jury listened to the judge's instructions and the judge instructed them that the evidence was irrelevant, is that what the point is, or was I jumping the gun?
No, the judge said specifically that the evidence was irrelevant.
Okay, then how does that hurt your client if the jury followed those instructions?
Well, the problem is the judge went on to make some confusing instructions. She didn't stick to that necessarily. Specifically, at the time when the evidence was introduced, and there were two prior bad acts, each time they were introduced, she gave instructions for how they were supposed to use them, and without reading verbatim, she didn't include that it had anything to do with the relationship, which was the sole reason that they really were being admitted.
Until the last instruction.
Right, the final instruction.
Would you agree the final instruction was a correct prior bad acts instruction, the one given in the jury charge?
It was. But at this point, we had a full trial, and there were previous instructions that were incorrect.
So the two prior instructions, the contemporaneous ones where the judge said these acts have no relevance with respect to the charges in this case, I've actually seen this in two other cases recently. Is that language part of a model instruction? Do you know where that's coming from?
I don't, Your Honor. I'm not going to mislead the court. I don't think it is, but my brother may know better than I.
Preview of coming attractions for the Commonwealth, they're going to get the same question, so. Okay.
Right. However, I had something brilliant to say and it left. I'm sorry.
Please tell us.
If it does come back, you will be the first to know. However, the reasons that the relationship aspect of it is still problematic. I'm not willing to yield that even if the instructions were by this court to be found perfectly allowable and it's not going to be a problem. These prior bad acts don't shed any real light that wasn't already shed. This is a real piling on of evidence of non-charged conduct. And if you look at the conduct, it's questionable as to why it came in at all.
It demonstrates quite clearly the hostile nature of the relationship the two had.
Right, but there's a point where the complaining witness, there's credibility issues clearly, but those are not to be argued here.
Was there a suggestion in the defense regarding the victim's failure to come forward initially? And if so, wouldn't the earlier prior bad acts at least show a pattern of conduct?
Well, I'm not making that, but because I'm not arguing credibility here. But what I am arguing is that the court seems to have given these confusing instructions to a jury of, again, non-attorneys. The judge determined and stated twice that the evidence had no relevance. Now, I understand that Justice Hand is saying that we are going to interpret that what she really meant was, or can I seek clarification from Your Honor as to what
Sure. I think I was, and maybe I was putting words in your mouth, which is not what I intended to do, but I was asking whether, if your point was that the judge's inclusion of the language about relevance of the prior bad acts information meant that she was ruling that that evidence was irrelevant and that the jury was going to follow that as an instruction and determine that that information was irrelevant. If those things were true, then my question is, even if that were all wrong or incorrect, how does that, or abuse of discretion, how does that impact your client negatively? Because then the jury doesn't consider the prior bad acts evidence.
Right, and I understand that my brother made that argument in a
I
footnote.
didn't come up with it myself.
Well, I'm sure you would have. But we know that there's no support for the statement he makes in the footnote. It's just conjecture, and arguments made in footnotes do not.
Well, he's not the appellant.
I'm sorry?
He's not the appellant.
True.
So he doesn't suffer any waiver problems that an appellant would.
Ultimately, the instructions were completely confusing. On this, I think we can agree, because we have two separate sets of instructions. In one, where it's irrelevant and it says nothing about the relationship. And I don't know that when we correct it at the end, we've really corrected the error. My argument is that we haven't. My argument is all we've done is we've confused the jury. And we've let in incredibly prejudicial evidence that really outweighs the probative value of it. He had many charges. I think we can understand, based on the charges that were made, that this relationship was not a good one. This was not an issue that had to be parsed or, made more clear for the jury.
But your client's position was, at trial, was that the victim was lying, right?
Yes, but
And misrepresenting the character of the relationship by doing that.
Well, I think, my client never took the stand, and the position of my client was that it was not a great relationship, but he didn't commit the acts of which he was accused. So I wouldn't agree with Your Honor that he thought this was an unblemished relationship or one that was going very well.
That's fair.
And if there's no other questions, I would.
I have just one.
Sure.
When you quote the judge saying that you consider the prior back solely on the limited issue of motive, state of mind, intent, plan, or absence of mistake or accident, and then you say that these were not in dispute, which you got from Creighton, which I've now found another place that Creighton has muddied the waters. But how is it not in dispute in this case? Did he somehow concede his motive, intent, or lack of accident?
No, but motive and intent weren't really the issue. In other words, an example would be a pattern. If someone was accused of something like a certain type or a distinctive robbery where there was always something said or some way, date, time.
Right, that would go to identity.
Then we get to pattern, but there's no pattern here. And I don't think these issues are at the thrust of an assault and battery case.
There's a pattern of him being abusive towards her on several different occasions. Right,
but all that does is cloud whether he was abusive this time. The question is he abusive now? That's really what in the cases where we allow this type of evidence, it's really about we've had cases, which I have in my brief, where the defendant had said, oh, we had a great relationship, and then the evidence was introduced that it was absolutely incorrect. There were previous problems. No such argument by the defense was made here. They had a bad relationship. I don't think that was ever in question. This is merely, look, he did these terrible things. He must have done these terrible things. And that is why it's so incredibly prejudicial and not probative at all.
Okay, thank you.
Thank you. Unless there are any other questions, I rest on my brief. Thank you.
Mr. Lee.
May it please the Court. ADH Lee from Middlesex on behalf of the Commonwealth. In Oberle in 2017 and Fernandez in 2020, the SJC reiterated that prior domestic violence is relevant to show motive, intent, state of mind, and the nature of relationship. In this case, the Commonwealth had to prove the hostile relationship because, like Your Honors observed earlier, the Commonwealth had to corroborate the victim's testimony. And in this case, there are 3 charged conduct or 3 sets of dates. One was in January 2021. The first 2 sets of prior bad acts goes to contextualize that conduct. And the 2 sets of charged conduct after that was about 1 year later in December 2021 and January 2022. The last prior bad act goes to contextualize those 2 charged conduct. Understand it's a 2-year relationship, but because the charged conduct were about 1 year apart, the Commonwealth had to explain that hostile relationship was continuous and not one-off incident, and that's relevant in this case. In terms of the limiting instruction in this case, my brother conceded that the final instruction was correct, and the only difference between the final instruction, the first 2 instructions, was one is the relevance common, the other 2 is the supplement, nature of relationship, and to Justice Neyman's question earlier, the relevance coming from the judge is not from the model instruction I have.
Where does that come from? Because I've now seen it in at least 3 cases.
I do not know, but I do know sometimes trial judges do share their notes. It's possible it's circulating somewhere, but I do know it's not from the model jury instruction.
Do you think that instruction is correct?
I think that instruction should be left unsaid. But to Justice Hen's point earlier, saying no relevance.
If it should be left unsaid, do you think it's probably wrong?
I think, like my brother is saying, yes, jury does not study relevance or study rules of evidence, but you don't need to understand rules of evidence to know what is relevant or what's not relevant.
If prior bad acts are being admitted into evidence, by definition, they need to be relevant, right?
Yes, Your Honors. But
so telling the jury that they're not relevant is probably a mistake. Would you agree?
Yes, but it will not prejudice the defendant in any way because if the jury is not considering it, it's not going to prejudice the defendant. And if the jury actually followed the rest of the instruction to consider them for the limited purpose in this case, that also would not prejudice the defendant because they are not using this evidence propensity, which is the reason why we have Rule 404, to use it against the consideration of propensity evidence, and that's what happened in this case. The judge forcibly instructed the jury 3 times not to consider these prior bad acts to the defendant's character or propensity to commit a crime. The judge gave proper limited purpose in the final instruction, supplemented that the jury could consider it for nature of relationship. The judge did not require the jury to consider these limited purposes for the evidence. It was only an option for the jury. As my brother mentioned earlier, these were correct in the final instruction. So given the fact that it was properly admitted under overlay, and the judge gave forcefully limited instruction, there was no error in this case, and this court should affirm the conviction. If there are no further questions,
Seeing none, thank you. Thank you both.
Thank you.
The next case is 22P1011 Commonwealth versus LUGO. Mr. Driscoll.
Good morning, and may it please the Court. William Driscoll for Richard Lugo. If successful on the first two issues in this case, Mr. Lugo is entitled to a new trial. If successful on the third, per Gardeno 2, he is mandated a new trial on the gun charges. On the first issue, the judge abused his discretion by allowing the peremptory challenge of a African-American juror for two causes. First, that he had a disability, a psychosis of schizophrenia that was treated. And second, because he was arrested 2 years earlier. As a result of that arrest, the juror went through mental health court, which is a very strict rehabilitative program. It's actually, in my opinion, much easier just to do the time than to be rehabilitated in his case.
So you say in your opening brief that this was a violation of the Americans with Disability Act, right?
I do, and where
But you did not raise that at trial.
No, it was not.
So how do we address a Suarez challenge for the first time on appeal when it involves findings of fact by the trial judge?
I believe defense counsel did raise the fact that his disability was not a factor in that he had...
It was not the basis of counsel's objection. Counsel's objection was this was the second African-American who was struck by the Commonwealth.
Correct, and later on when he was also arguing the fact that his brother being arrested on gun and drug charges and federally incarcerated was also...
And Juror 31 himself had gun charges, correct?
No, he had a breaking and entering in the night. That was his charge that he was arrested for and attended drug court. And that drug court was successful.
So, all right, so let's get back to my question. How would we address a Batson-Suarez challenge for the first time on appeal when it involves findings of fact by the trial judge?
By taking a look at Haywood.
I'm sorry, what?
Haywood, where there was a blind potential juror that was impaneled without objection, so a substantial risk case. And the court found that a blind person could sit and view the photographs, if you will, with the aid of another juror. However, it was not an ID case, so there was no error.
Was that raised at trial, though?
In this case?
In Hayward.
In Hayward, there was no objection at all. And yet the error was that a jury of your peers includes disabled individuals. And in this case, you cannot keep a blind person off the jury just because they're blind. This was not a case of ID as in Susi. Therefore, in Haywood, you could not keep that blind juror off the jury. You had to allow the blind juror to sit.
The Commonwealth makes the point that even if it's raised that suffering from mental illness is not a protected class of those that make the statute applicable.
True, and that's where the confusion comes in. The argument is that this is a race-based challenge. We had a black juror that was being excluded. Were the reasons
Well, all right,
adequate?
let's, I mean, you try to make it clear in your reply brief that it's a race-based challenge, but in your opening brief, the one that matters, you say this is an ADA violation. And the Commonwealth also wants to know why you have standing to make a third-party challenge on behalf of this juror.
Okay, I did cite in a footnote that there is precedence for a third-party challenge of a juror's rights by the defendant. And the reason why I rest the disability, if we take a step back to Maldonado, yes, this was an adequate challenge by the Commonwealth because clear, reasonably specific to that individual juror and related to the case. Okay, it's actual. My argument was it was a sham. It was not genuine. It was not the actual intent of the Commonwealth. The Commonwealth's actual intent was to remove the African-American juror from the panel for two reasons. Number one, his disability. Disability-wise, there was nothing wrong with this individual. He was fully medicated. He's on monthly Halidor injections from the BMC clinic, and there was absolutely no reason why he could not sit on this panel. And that's why I raised the ADA and other challenges, the disability challenges.
Judge Sanders refused to strike the juror for cause, although she was initially concerned about his mental illness. He was medicated by his own representation, so she was not going to entertain it for cause.
Correct.
But then she goes on and explains that even though he is African American, the juror has friends that were charged with murder and convicted of murder, and he has a brother that's facing gun charges, and then she finds that these are all appropriate group neutral explanations for what's being offered here. Don't you have to show that that's clearly erroneous based on the record?
Well, actually, if I may correct, Your Honor,
I'm reading the transcript.
the juror's brother was in federal prison for gun and drug charges. The Commonwealth associated that with another African-American juror that was stricken earlier, and that prior African-American juror that was compared had 5 or 6 close personal friends convicted of murder, some he considered family. He believed one of them was wrongly accused yet convicted. Those cases, some of those cases were tried in Boston, the same court as the court for Mr. LUGO. He remained in contact with his incarcerated clients, and he felt that as a child, he was wrongly charged with assault. So that was what the Commonwealth said. This is the analogous to the juror I'm trying to strike because his brother is in federal prison for gun and drug charges.
And why aren't those race-neutral reasons?
Because in this case, unlike the prior juror that was compared, this juror had no real association with his brother. He had nothing to do with the trial. He was not close to his brother. He didn't maintain contact with his brother. He was completely differently situated from the reasons the Commonwealth associate with the prior African American that was stricken from the panel.
So as I understand your argument, you're saying that you're conceding that the reason is adequate and race neutral, but you're stating that in your view, when you peel the layers, it's not genuine, correct?
Yes, Your Honor.
So let's get back to Judge Meade's question. Here, my understanding is that Judge Sanders made a determination on the record that the reasons proffered were 1, adequate, and I believe she also said 2, genuine. Is that correct?
Correct.
So as Justice Meade said, we would need to find then that her finding, because it's a finding of fact, was clearly erroneous. How do we do that on this record?
By the factual comparison.
You're asking us to weigh credibility of a dialogue that went on before, among the judge and the two attorneys that she was privy to. How can we go back and say, well, no, clearly that those reasons aren't credible and genuine on a stale transcript?
By looking purely at the facts. The Commonwealth compared this first juror that was excluded, who had very bad feelings about the criminal justice system, very close connections with murder, incarcerees, kept in contact with them, et cetera. And on the other hand, you have the juror in Mr. Lugo's case, whose brother was in federal prison on gun and drug charges. There's no indication he had anything to do with that.
Why does that comparison matter?
Because factually, if you take a look at that, he's being kept off because, as the judge said, because of his prior arrest. Oh, he was unmedicated when he broke into that house 2 years ago. Yes, but he's been rehabilitated through drug court. He's had therapy. He's had 1 year of follow-through on his medication. He has monthly injections. There's absolutely no reason why his schizophrenia would affect his standing on this jury or ability to converse with others on the jury. Very different cases here. I think factually you can say that the judge made an error, that the judge...
Before you run out of time, can you get to your second issue?
Yes, Your Honor. The Commonwealth used Mr. Lugo's pre-arrest silence against him 3 times during the trial and once in closing argument. At trial, over objection every time, the Commonwealth asked, well, after the shooting, did you call the police? Did you go to the police? Objection. Same thing again. Well, when you went to see Jocelyn, she had a phone. Did you call the police? Well, objection, sidebar. Implicates an affirmative duty to contact the police if he was truly innocent, was his attorney's argument, and the judge says it's allowed. So again...
I mean, there's a fulsome discussion of this on the record before the trial prosecutor asks these questions, right?
I'm sorry, I missed part of that.
Before the prosecutor asks these questions, there's a discussion with the judge, and the judge stops and makes sure that the prosecutor knows what the limits are and what she can do, and then she can ask him if he called the police, but she can't ask him or even suggest later in argument that it was only natural for someone who's telling the truth would have done so. But someone who has claimed now to be a victim of a violent crime, you can ask them if they went to the police or if they tried to get medical attention. Those by themselves, without the second part, falls into the exception.
Your Honor, I respectfully disagree.
Okay?
If there's a medical condition, as in Barnowski, which is distinguished in Gardner, our supporting case, where the friend of one of the shooters didn't call the police, and his friend lay on the ground for 45 minutes before any contact with medical personnel. It would have been natural for him to call for an ambulance when his friend was lying on the ground, shot.
Well, in this case, Mr. Lugo was very badly beaten, according to the...
Yes, but what the judge never did was examine the Commonwealth's use to find out why would it be natural for someone in Mr. Lugo's condition to call the police and implicate himself in a crime. And that's exactly what Gardner says, and Gardner is 100% on point. The defendant was killed in self-defense. The defendant used pre-arrest silence in trial and also in closing. It would not have been natural for Gardner or Mr. Lugo to implicate themselves or volunteer any incriminating information to the police, even if they were acting in self-defense. And there is no compulsion to speak or to remain silent.
So just one thing before your time runs out. After Guardo 2, you're not entitled to an acquittal, right, on the gun charges? You get a new trial.
No, it must be a new trial.
Right, okay.
There was a case forwarded on a 16L letter.
Yes, okay, I just want to make sure that we're
That
on the same
predated
page.
Gardeno 2.
Yeah,
So under Gardeno 1, it would have been correct. Subsequent law, no, it does not apply. New trial.
okay, thank you.
Thank you.
Thank you, Your Honors.
Ms. O'Connell, please.
Good morning. May it please the Court, Kyle Sikanolfi for the Commonwealth, asking this Court to affirm the defendant's convictions. Turning first to the allegation of error in jury selection, the record is clear. There was no error. Judge Sanders acted within her considerable discretion in allowing the Commonwealth's peremptory challenge for reasons wholly unrelated to the prospective jurors' membership in any protected group, and did make express findings, as Justice Neyman, you pointed out, that the reasons offered by the Commonwealth were both adequate and genuine, and where the record supports that determination, this Court will not disturb it, I believe, based on the case law. Here, the reasons offered pertain to the jurors' past personal and family experiences with the law, which can form a legitimate basis for such a challenge, and the jurors' self-identification as having a mental health disorder. That...
What about, let's get back to the procedural problem that I have.
Yes, sir.
There's no ADA claim made at trial.
Correct.
And you tell us that we can review for a substantial risk of miscarriage of justice.
I think the Court doesn't need to reach it at all where it wasn't the basis below.
How do we even review it for substantial risk?
In the sense that the challenge wasn't preserved below on those grounds.
No, I understand that it's waived. My question is, it's similar to what I asked Mr. Driscoll, is that this involves factual determinations made by the trial judge not on the race issue, which she does make, but on the disability issue, which was not put to her. So how is we in a position for us to determine that the peremptory challenge was genuine when that's a factual determination?
Well, the judge did expressly find it to be genuine. There's not reason in the record for this Court to revisit that finding.
No, I just thought you knew something that I didn't know about how we'd go about doing this. I've never seen a peremptory challenge argument raised for the first time on appeal.
I would suggest that Your Honor has seen the presentation far more than I had, and I can assure you I'm not privy to information Your Honor doesn't know. What I think is important is that Judge Sanders considered the issue of reported mental health disorder and examined whether that was a basis herself to excuse him, this prospective juror, for cause, and found that she was satisfied based on his representations that he could serve. But as the Commonwealth argues in its brief, those representations don't insulate the juror from challenges by either party under peremptory challenge for reasons related to his capacity to serve, or the other reason that he himself had prior and recent experience with the law, so too for his family member.
Has disability ever been held to be a protected class within the meaning of Article I of the Massachusetts Constitution?
No. And
have we ever commented on it, or the SJC, or is it just?
Not that I have found, Your Honor. The groups that are protected groups for purposes of the bats and swords analysis are those identified in Article 12 and Article 1, recently expanded to address or incorporate sexual orientation into the sort of constitutionally prescribed categories, but that's the extent of the express incorporation of what constitutes a discrete and protected group for these purposes.
What do you say about Hayward?
I think Haywood is not applicable here. In Haywood, the defendant on appeal challenged that a blind juror was sat, and he suggested he was deprived his right to an impartial jury, where that juror's disability physical disability could have prevented his fair understanding and analysis of the evidence, and the court rejected that claim. There was no challenge to the juror being sat. The court inquired of the juror and found that based on that particular case and set of facts, he could competently serve with some assistance from fellow jurors. So it's just not what the facts were presented, or argument really is presented for this court's consideration. Turning to the issue, the challenge in the evidence for the Commonwealth's cross-examination of the defendant and closing argument. Here, the prosecutor, question by question in her cross-examination, dismantled the defendant's version of what transpired here. And incorporated in that was reiteration of the fact that the defendant did or didn't do certain things immediately following the event. Based on the defendant's own testimony, he did not go to police or seek medical attention immediately following this alleged brutal assault that he says he had suffered.
Could I ask this question? Does the Commonwealth suggest that we are asking ourselves in a real-world context whether the defendant in these circumstances would be expected to call the police? Or is it more of a legal fiction that we're being asked to apply?
I think it's looking at the facts as they're presented in a real-world common sense understanding. Would it have been natural for someone in the defendant's shoes, if it happened the way he described, would they seek help from the police? Would it be natural for them to do so? And those facts, I think, were apparent in this case, where the defendant alleged that he was the victim of a particularly egregious beating that left him within an inch of his life, where his back was against the wall and he essentially escaped death by shooting his assailant.
Well, you distinguish a number of cases where the SJC or our court has found comments on pre-arrest silence to be error, and you distinguish those cases from these facts. I understand that. I don't see you citing to any precedent, though, that says comments of the nature that were made in this case are indeed admissible. So what's your best case for that proposition?
I think the Barnowski case. In that case, there were questions, repeated questions put to the defendant about his behavior after he supposedly witnessed someone else shoot his friend. And it was interwoven set of questions where the prosecutor established that despite multiple opportunities, the defendant didn't contact the police for help, that he didn't call for an ambulance for help. And here, the court found that was an error because it those facts created an incentive for the defendant to seek help from police or seek medical help for his friend. So that was an error, and I would suggest these facts establish the same.
I thought what made it permissible here was that the prosecutor only asked if he had called the police, and you can't then go on to suggest that if he was telling the truth, he would have called the police. I thought that's the problem with this, and that's what they discussed at sidebar with the judge. And the prosecutor didn't do part two, which is what the defense was objecting to, saying that he had an affirmative obligation. It would imply that he had an obligation to go to the police, which he does not. So you said before, in answer to Justice Hand's question, that it would have been natural for someone telling the truth to have contacted the police, but I thought that's the forbidden part.
Well, I should clarify my response. What I mean when I say it would be natural on these facts for the defendant to contact the police, it's not on the suggestion that an innocent person would do so to claim their innocence or claim their self-defense. It's related to the facts that if the defendant was injured in the way that he claimed in his trial testimony, it would have been natural, and where he, by his own word, left his alleged attackers alive, moving about with access to multiple firearms who know him, it would have been natural for him in those circumstances to seek help from the police, and he didn't do so. So that is a turn of proper impeachment or demonstration of why the defendant's version of the event isn't credible. rather than a suggestion that he had some affirmative duty to contact the police or that an innocent person might. And again, it was part of the defendant's own testimony that, it was clear from the defendant's own testimony that he did not do so. And in argument, I think the prosecutor rightly connects that together to say he made decisions to avoid the police because he wasn't injured in the way that he was claiming. And she goes on to point out that certain physical evidence that would have corroborated his claim wasn't at the scene, and that woven together was why the jury could find his version of the events implausible. Turning to the third issue on the firearm counts, I would like to acknowledge to the court the 16L letter that was submitted, and recognizing that what's underlying the Commonwealth's argument here is the facts established by the defendant in the course of his testimony that it wasn't his firearm. There are facts that the Commonwealth suggests show he was not familiar with the use of firearms, he was nervous in handling it, it accidentally discharged, and those are facts the Commonwealth points out in support of its argument for why lack of instruction here was harmless beyond a reasonable doubt. I submitted the Gibson case, to the court because further inquiry into those specific facts do show that the SJC was looking at a set of facts which included a defendant using a gun that wasn't his to commit the crime. And in passing on the sufficiency of the evidence in that case and in passing on the lack of instruction on the case, the SJC found a new trial was warranted. So I just wanted to make sure that was before the court's attention. And if there are any questions, I'm happy to address them.
Under the circumstances, it can be affirmed that he was unlicensed because he picked up the gun that was not his. And why wouldn't it be or why couldn't one infer that he picked up the gun that was not his and he was licensed?
I think where there's additional indicia of his lack of familiarity with the firearm based on the manner in which he described being nervous and handling it, and it's accidental, what he claimed was an accidental discharge, that distance him from a person who might be lawfully licensed.
But Gibson doesn't bless that, though, right?
I'm sorry?
Gibson does not bless that thought.
I didn't hear the last part of Your Honor's sentence, I'm sorry.
Gibson doesn't support what you're saying, what you're arguing here.
It's not clear from Gibson if that argument was before the court, but I want to flag that the facts at Gibson, share some similarity to the facts the Commonwealth's offering here.
Thank you.
I appreciate the court's time. Seeing no further questions, the Commonwealth will rest on its brief.
Thank you. Want to do another one? The next case is 2023 P653, Department of Children and Families and another versus Mother and another. We're missing. All right, then we will take a break.
Court is open. Please be seated.
Okay, second try. The next case is 2023 P653, Department of Children and Families and another versus Mother and another. Ms. O'Brien.
Good morning, Your Honors. Tamika O'Brien for the mother. I'd like to start by thanking you for postponing this case due to the snowstorm that didn't happen. Your Honors.
Let the record reflect there was some snow south of Boston.
A little storm that couldn't.
Good morning, Your Honors. Justice Meade, I recall you asking us to get right to the point, so I'm going to get right to the point. In this case, Your Honor, mother's not arguing that she was fit at the time of trial. However, what we are arguing today is that the problem in this case is even if the trial judge's findings and facts are not clearly erroneous, the trial judge's ultimate conclusion that mother's unfitness was terminal was an abuse of discretion. Here, mother's efforts cannot be discounted, and when you look at the terminal unfitness, this trial judge was obligated to look at all of the evidence. Mother, in this case, in the months leading up to trial, while she did have some setbacks, she was improving and she had demonstrated that she was capable. And DCF's records in the months before trial showed that she was, in fact, improving. In 2021, the YMCA, who was supervising mother's visits, recommended that those visits be unsupervised, and DCF agreed and allowed mother to have unsupervised visits with her child. In January of 2021, and now that I think about that, it might have been 2022, so forgive me if I got my years mixed up. DCF told the court investigator that mother had grown and matured and that she was easier to work with. They acknowledged that they allowed mother to have unsupervised visits in her home, despite their concerns about her home. In May of 2022, the foster care review team reported that mother had showed insight. She was doing a good job with her child in her visits. When the child demonstrated that she was having some difficulty with transitions, mother agreed that ending the visits a few minutes early would be helpful for her child. Those visits weren't ended early by DCF. It was mother who had the insight and agreed that the visits should be ended a little bit early. In the foster care review in May of 2022, mother reported that she had friends and supports, which is something that in these cases is really, really important to establish stability. The assumption here that mother was unfit and that she would always be unfit was wrong. When you look at all of the factors and the findings, finding 99, 105, 112, 120, 128, these all demonstrated that mother was not incapable. The trial court judge in this case actually noted that mother was highly intelligent and had a willingness to learn. And yes, she had her issues. If she didn't have her issues, we wouldn't be here today. But those issues were not so insurmountable to show that there was clear and convincing evidence that her unfitness was terminal in order to support a termination of her parental rights with this child.
Can you point me in the direction of the evidence that shows that level of improvement or improvement trajectory as far as the mother's anger management is concerned?
Sure.
And
I think that in this case, mother had been working really hard. She had done an impressive, and the trial judge did note this, an impressive number of parenting classes. She was doing a lot of what was on her service plan, but the missing part here was that anger management component. She was waitlisted for that, and I think that, Your Honor, if you look at her history and, you know, Mother is not saying that she did not have her faults, and a lot of her faults were around her anger management issues. And it's Mother's contention that that one piece was missing, and she was on a wait list, and if had she taken that course, perhaps she would have been able to show some improvement in that area as well.
But is your client's position that it's just a question of her having taken the course, or that taking the course would have had a dramatic impact on her ability to manage her anger, or both?
I'm not entirely, I don't think anyone's in a position to say, had I taken this course, I would have, you know, not had these problems. But perhaps it, you know, I think that that was just a missing component here, that everything else seemed to be falling in line. And perhaps that course, or engaging in some kind of anger management program, would have put her back on track in this case. Did that answer your question?
It did, yes, thank you very much.
Again, Your Honors, something else I think that is important to discuss here is that DCF said that Mother was doing a good job with her child in visits, but then also complained that she wasn't managing her child's behaviors, and her discipline of her child was, you know, was not what they wanted. In the foster care review in 2022, in May of 2022, the foster care review team recommended that DCF help redirect Mother in those moments. And if you look to November, and I believe it's finding effect 130 or 137, if you look at that period of time, at that point, DCF had given up trying to help Mother. They had literally told her, just enjoy your visit with your child. And then at trial said, oh, she wasn't able to appropriately discipline her child and use the skills, such as the 1, 2, 3 magic, that she had learned in her parenting courses. She wasn't able to demonstrate those skills because DCF said, just enjoy your visit with your child.
Am I incorrect in understanding that the department's concern, at least as it was articulated in the findings, was that the mother couldn't get off the concept of using the entire time to be disciplining the child, and was not, in the department's view, having any other exchange with the child beyond that? Is that a fair characterization of the way the findings read?
Your Honor, DCF was tasked with helping Mother in that situation. They had provided a parenting partner, but there's no evidence that shows that that parenting partner was actually in the visits to help. So DCF was under an obligation to assist Mother in that situation. Just telling her to not do this was not what they were tasked with doing by their foster care review recommendations. Your Honor, in this case, there has to be no doubt that a parent's unfitness will continue indefinitely. And in this situation, that there was doubt. Mother was on an upward trajectory and was capable, and therefore her fitness was not terminal. I'm sorry, her unfitness was not terminal. Your Honors, if you have no other questions, I'll rest on my brief.
Seeing none, thank you.
Okay, thank you.
Mr. Sack.
Good morning, Your Honors. My name is Daniel Sack. May I proceed?
Yes.
In finding Mother unfit by clear and convincing evidence, the trial court appropriately relied upon a constellation of factors focusing on Mother's patterns of behavior. Unlike the trial court's ultimate finding of unfitness, those subsidiary findings need only have been found by a preponderance of the evidence, and the trial record here amply supported each of them. On appeal, oh, sorry, Judge Neyman, do you have a question? Oh, no.
Not yet.
I apologize. Thought you had a question there. On appeal, Mother focuses on 4 in particular. On 4 subsidiary findings: Mother's pattern of engaging in incidents of domestic violence, Mother's pattern of failing to keep a safe and stable home, Mother's pattern of engaging in harsh and hostile behaviors during her limited interactions with child, and 4th, her Mother's pattern of engaging in antisocial behavior. The trial record amply supported each of them. What I heard today from my colleague on the other side is that she's really asking this court to do something which this court has repeatedly said it cannot do, which is to re-weigh the evidence and to re-weigh that evidence in her client's favor. For those reasons, we ask that this court affirm the judgment below. I'd like to focus specifically on anger management, which Justice Hand, I believe you raised during my colleague on the other side's time. Here you had asked whether it was enough that if mother were to just take a course, whether that would be sort of sufficient to show that she could improve. And I think what the SJC and this court have repeatedly said is that it's not enough simply to take a course and hope that it improves. What the courts look to is outcomes, not just inputs. And I think we saw that repeatedly with her child parenting classes. The trial court recognized that she had engaged in a number of them, but that ultimately they hadn't improved her relationship with child. And so I think Your Honor was right to focus on sort of the fixation on punishment during those limited interactions with child, rather than sort of hopes about the future, right? Where the courts are focused on probabilities, not possibilities in this circumstance. And the probabilities here all pointed to the fact that mother would continue to be unfit.
So I have a question. One of the difficult yet critical things for a parent to do in these cases is to demonstrate stability. And we have a conclusion of law here by the judge. It's conclusion of law 12, which in part says mother has a penchant for moving to a new area to improve her access to housing and services. This pattern has not been effective, nor would it be beneficial to the child's need for stability in light of her deficits. So what is mother to do in a case like this, where she needs to show, in order to comply with her action plan, her tasks, that she is getting the proper services and she has access to housing, and yet when she's moving to obtain better access to these things, the finding is, well, you're not showing stability. That's a really difficult conclusion of law here to deal with.
Yeah, so I understand Your Honor's question. Respectfully, I don't think it's that difficult when we understand stability in a more holistic sense. So I'll address both stability in terms of a healthful home, which I think the record shows mother failed to maintain consistently. But then I'll also turn to sort of your point about moving around. So on the first point, there was evidence that mother's home was continually kept at an unsafe level of cleanliness, right? Or not just talking about some sort of scattered belongings, but really that there was routine chokeable hazards in the home. And in fact, when early intervention workers entered the home, they had to clear space so they could interact with child. But more than that, there was an unsafe level of bleach in the home routinely. DCF workers had to continually step out of the home due to the intense odor of chemicals. And at mother's last home visit, she actually refused entry to the DCF worker and warned that it was unsafe for her to enter due to an intense chemical smell. But to Your Honor's point about stability in terms of where to go, I think the record shows that mother had ample, that DCF provided ample opportunities for services. The mother frequently rejected them. For example, it offered to find her anger management services, and she declined. It offered to place her in domestic violence treatment programs. Mother said she was capable of recognizing domestic violence on her own and refused that treatment. And I think the evidence shows that multiple times mother left a situation where she was receiving services, sort of, right, instead of addressing her own problems and how she handled those, the treatments that she was receiving, she sort of just opted to look elsewhere. So for example, when she was pregnant with child, DCF cautioned her not to move away because it would be difficult to find resources there. She did move away, and the trial court found that that did impact her ability to receive services. Later on, she planned to move out of her, I believe, her own grandmother's home, who was helping provide care for the child. and DCF warned if she did so and moved in with her abusive partner, that it would seek to take custody of the child, and she did that again there. So I think there have been multiple instances where the record just hasn't borne out that mother wasn't receiving enough treatment or quality treatment where she was. If there are no other questions from the court.
Seeing none, thank you.
Thank you so much.
Mr. Cohen.
Good morning. David Cohen on behalf of the appellee child. Child asked you to affirm the lower court's rulings in all respects for many of the reasons that my colleague just itemized. In terms of a few of the questions, I think he answered them in large part, but I may be able to add one or two facts to supplement that. I mean, mother certainly had an anger management problem that persisted. So, I mean, she pulled a knife on her own mother back in December 2014 and January 2015. I mean, these are historical things, but you match them with, which I'm sure you've seen in the briefs in the record, you match them with these incidents of being arrested 1 or 2 months before trial for assaulting her mother, and also for basically going after her former boyfriend and going to his house and smashing his things. And there was a restraining order where she's alleged to have pulled a knife there. So you have these bookmark issues. And then the question about, well, she was on a wait list, but the trial court discredited that the wait list was the reason she couldn't pursue anger management. And Attorney Sack, I think, just mentioned that in passing, that the social worker had offered, well, let's call another program. And the mother said, well, no, I don't need that, or I'm fine. But then we have a domestic violence incident shortly thereafter, or within 6 months, whatever, and this is also after mother said, I don't need domestic violence services, and I've separated from the most recent partner with whom I've been involved in domestic violence. That's Mr. A. That was somewhere about 4 to 6 months before trial, and yet we have these incidents right next to trial. Housing, it's a similar thing. With I agree that the choice of a penchant for moving from the judge is an interesting choice of words, where mother had been in this apartment for years. However, the apartment was not suitable and stable, and that had been the case for a long time, and mother didn't seem to be able to remedy it. You know, she presented it and said, this is a problem with the landlord, it's not properly taken care of, I've complained. The trial court discredited that reasoning as well. So again, this court is not going to reweigh the facts, and the reasons mother gives for not benefiting sufficiently from services, which is really the issue here. I don't think child would dispute that mother may have made some progress, but this is a child who mother had lost her to DCF, you know, within the first year of the child's birth, when she moved away, when DCF was trying to implement services, had mother had been reunified with the child. A few years later, the child is 2 or 3, and still within 4 months, you know, these sorts of problems come up again. And so this would be, and this is now the child is, you know, at the time of trial, 7 years old. So these problems had persisted for quite a number of years. And at a certain point, our case law says the court has to say enough. Childhood is fleeting, and this child was, you know, and is well situated with kinship placement that has cared for her for many years now and wants to remain there. If there are any questions, I'd be happy to answer them.
Seeing none, thank you. Ms. Silver.
Good morning, Your Honors. May it please the Court. My name is Allison Silber, and I'm here this morning for appellee father, who respectfully requests that this honorable court affirm the lower court's judgment terminating mother's parental rights. I'll briefly say, Your Honors, that my client has standing to be here this morning because he struck a bargain He stipulated to his unfitness and gave up his due process rights to a trial in exchange for an open adoption agreement with his own brother as the adoptive placement and post-adoption contact. If this judgment were to be vacated, my client would lose his benefit of the bargain. He would no longer have the adoption by his own brother. My brother's counsel this morning have talked about important details, and I would like to zoom out to talk about the big picture, which is that although mother possibly has improved some small amount, she has not improved enough. There are three main issues with her failure to improve. First, she failed to use services either consistently, such as therapy, she just was not consistent with her therapy, or she used services such as the court acknowledged an impressive number of parenting classes, and yet she didn't improve from those classes. We heard this morning Mother's Counsel talk about how there may have been 1 or 2 positive comments during her supervised visitation, but mostly and largely these visits were highly problematic. Mom was punitive to the child during her visits. Mom engaged in inappropriate conversations with the child during the visits. Mom had excessive discipline during the visits, so much so that the trial court found that mother's fierce rigidity was ineffective at best and cruel at worst. The second major issue relating to mother's failure to improve has to do with mother's failure to have appropriate housing. My brother's counsel have discussed this. I'll just add that in addition to failing to have a safe and uncluttered home, mother also owed back rent at the time of trial and was facing eviction. The third main issue regarding mother's unfitness was how domestic violence was a continuing issue in mother's life. We heard from mother's counsel this morning that mother believed she had supports and friends in place to help her as a parent, and yet in the 4 months prior to the trial, she was involved in 3 domestic violence incidences in which she was the perpetrator all 3 times. In closing, Your Honors, mother's continued role in the child's life would have placed the child at serious risk of peril from harm, neglect, or domestic violence. We respectfully request that the judgment be affirmed. Thank you.
Thank you. Thank you all. We'll take it under advisement. The next case is 22P1063, John Doe number 372711 versus the Sex Offender Registry Board.
Good morning, Your Honors.
Very impressive.
May it please the Court. As I'm apt to do at times, I like to start out by reminding the Court of something. And in this particular situation, it happens to be a remand order from this Court on August the 9th, 2021, in which members of a panel, including Judges Henry, Sachs, and Singh, said, "We cannot be confident that a level 3 classification is warranted without consideration of factor 2. There is only one sex offense." 5 years, how many years later is it now? We're back with the same thing. My argument is, I really think that this case emphasizes one of the problems that exists with regards to many of these individuals who, frankly, didn't have the best of criminal records. And that is it because you are a criminal that you also are a sex offender, and as such, you should face a level 3 classification? My contention is that's not supported by substantial evidence. We can talk about factor 9, we can talk about whether there was evidence of abuse or there wasn't evidence of abuse. It was conceded at the Superior Court level. I love my brother because he found a case that said you can still consider it. Fine, do so. That said, I mean, there's still no evidence that it contributed to the offense. The factor says it's got to contribute, it's got to be ongoing, and the like. None of that was there. Was he a drug dealer? Maybe. But did he use? No. And that's what the factor looks at.
What about in prison?
Same thing. No evidence he used. He got Suboxone strips, but there is a reference in the record that
He's
says.
making home brew too, right?
Yeah, but that still doesn't mean that he was using
Having
it.
his own makeshift bar in the prison?
It could have been. But
been.
that said, it doesn't establish use.
It's a disciplinary violation, you say.
Still may be, but it's not use. Use means something that shows that it has an impact upon his behavior, because the beginning of that factor talks about substance abuse being a disinhibitor. That means ingestion. That means use. There's no disinhibition if you're a manufacturer or otherwise, and there's a reference in, I think it was the intake report that says he is known to be one of the drug dealers in the institution. Again, he doesn't get a gold star for behavior, but that doesn't make him a sex offender.
Can I ask this,
Yes,
Attorney
ma'am.
Burkhardt? If we took factor 9 out of the equation, am I understanding your argument correctly that you think that either the regulations or the examiner or both then put too much weight on the fact of the extensive other criminal record?
Without any question, because the only factors that are applicable is the age of the victim. She was 15. Certainly she falls within the guidelines, but I think we have to look at it in the framework of the situation that she was in. And there's no evidence to suggest that she was being compelled to act in the manner that she did. I'm not condoning it. I'm sure there was pressure, whatever the fact is, but there was no violence or otherwise, and she was 15 years old. She wasn't prepubescent. It's a factor, it applies. I'm not going to say it doesn't. Same thing applies with the factor 7. I'm not going to argue that the relationship may have been extra familiar. Where the meat comes in this case is whether or not there is any risk aggravating factors past that. And the ones that are relied upon are criminal record, violence not involved in the sexual actions, and then his behavior in prison. So, again, we get back to my initial question, and that is, does that make you a sex offender? And then we get to the issue of the studies, and we get to the antiquated regulations that we have, and the ongoing battle that continues to exist with regards to what studies to believe by the same person. Dr. Hansen originally said back in, 86, he said, maybe it was later than that, 98, that things like the nature of the victim, the amount of use of force, et cetera, they don't predict risk. And then the analysis was done by himself and Dr. Bergnan that said antisocial orientation may be indicative. The point is this. It may say that you're going to be a criminal, but does it say that you're going to be a sex offender? And I think in that scenario, we have to look at history. And history says his only offense was in 2011.
Why can't we also look at trajectory, though? If you take someone who has, for example, a long history of lawless behavior, who then decides that the lawless behavior is going to expand into this area of sex offenses in a couple, and just say it expands into sex offenses, why isn't that permissible to look at the past as predictive of the future? If this continues to expand, then yes, there is an increased risk of repeat conduct, and that the danger of sexual reoffense is high based on what has happened up to this point.
You can. There's a case called Hill. It's
Right.
applicable in sexually dangerous person evaluations and commitments, which says you can extrapolate. Let me pose the question to you this way. At what point with his record is he never going to not be a level 3? That's where the problem occurs. Is we had conversations, my client and I, with regards to submission of risk mitigating factors. He's not a fool. I mean, he did some college. He said to me, what's going to make a difference when, in fact, I'm working for my mother and I'm otherwise not getting in any trouble, but I got my criminal record and the like, they're going to keep me as a level 3 forever. And you know,
I know.
well, I mean, and then the next question I anticipated from the court was, why am I here? When he could be in a reconsideration or reclassification, and the same thing is going to apply when he gets there, which is he's got a terrible record, he's a criminal, and therefore, I don't doubt that the recidivism rates for criminals are there. I just don't think that the extrapolation without anything more should be enough to say you're a level 3 sex offender. Make them a level 2, put the public on notice. The difference between a level 2 and a level 3 is vast.
Can I ask a question that's unrelated? Here, step back. This is one that I just need some explanation on. This is the second challenge to the 2017 classification, is that right?
That's correct.
And was the Factor 9 issue raised in the first one?
It's a very good question, and I don't remember.
I didn't.
It was raised at the Superior Court level after the spree classification. That's where it was conceded by former board counsel Attorney Basse. It was addressed in the hearing decision, but whether, frankly, I don't think I brought that. Well, did I? Maybe I brought it. If I brought that earlier decision, I might be able to answer your question. Let's see. Here it is.
I didn't see it, and I didn't mean to use up a lot of your time on that.
No, that's fine. I don't have a lot more to say anyways. I think my argument is clear in my brief, and it's the same argument that I frequently make, which is, at what point do we not? I don't see it referenced in the judge's analysis. Talks about 3. I'm talking about the former or the remand decision, and I don't see it mentioned in there. And I did not bring, oh, wait a minute, here it is. No, several moderate weight to 2, 3, full weight to 19, minimum weight to Factor 9. So, was it challenged, is the question? I can't answer that.
Okay. Is it, if not, does that impact our consideration?
No, I don't think so. Just like my brother says that you're not bound by a concession, I'm going to say the same thing.
Thank you.
I really have nothing further unless there's any questions.
Nope, seeing none, thank you.
Thank you.
Mr. Shinai.
Thank you. If it pleases the court, David Shinai for the board. I just want to do a disclaimer. After spending an inordinate amount of time with my small grandchildren, I've developed an eye infection. So if I'm blinking, it's not that I'm winking at you. It's just that it's getting a little itchy. I think my brief pretty much sums up the board's position in this case on this individual. And I think the main argument really is, even if Factor 9 Factor 9 should have been considered. The hearing examiner gave it minimal weight. I don't think it impacted the decision such that a reversal would be required in this matter. This individual from 2000 to 2008 amassed one of the largest criminal records I've ever seen in less than a 10-year gap, and he continued it through his incarceration. And the reason why I resurrected the whole idea of possession is that homebrew. That's really hard to do in a prison. And it's not like you can then take homebrew and start bottling it while you're in prison to sell. I mean, it's an indication of this individual's having some type of substance or using substances of some sort. I also think there were also possessions of drugs. And looking at the criminal record this individual had, I think common sense says that it's usually with that much criminal activity, that much violent criminal activity, substance abuse is usually involved in that. So I think it's not unreasonable to think that the idea that this individual had substance abuse issues, I think it was reasonable to think about that. I think the hearing examiner conceded that there wasn't evidence of actual usage, so even the hearing examiner conceded that point by saying, but I'm going to attach minimal weight to it because substance abuse or substances are involved in almost everything he's done throughout his career, including while in prison. So I think, again, I think the strongest argument is that applying Factor 9 at minimal weight did not materially affect the Level 3 classification with this individual's background in sex offending behavior. And I think I've outlined it pretty well in my brief. Unless there's specific questions, I'd be more than happy to rest on my brief.
Seeing none, thank you.
Thank you.
Both. Our last case is 23P575, Town of Easton and another versus EASTON MHC, LLC. Mr. Kraus.
Good morning, Justices. Or good afternoon. No, good morning.
Still morning. Mr. Kraus, sorry about that.
Justice Meade. May it please the Court, my name is Robert Kraus, and I'm here on behalf of the appellant. What I'm asking for today is that you allow our appeal to go forward, and I'll explain it, but it's essentially our appeal on the sale method, our appeal of whether Chapter 111, 127I allowed the court to wipe out secured mortgages of record, and the bond amount which Judge Perino set. As you know,
I'm sorry to interrupt already, but what do we do with the fact that you didn't file a notice of appeal from the final judgment?
Your Honor, I believe that if you look at the docket, I think it's pages 18 through 22, we did appeal in every instance that we complied with the spirit.
You didn't name the final judgment, though.
Well, our appeal, as noted in the record, essentially took up the entire substance of the judgment. There's no lack of notice that we're appealing. In July of 2022, we appealed Justice Sullivan's decision with respect to allowing the sale at $700,000.
Is that Record Appendix 101 and 102? That's what I have. Filed July 5th, 2022, defendant's notice of appeal of endorsement on motion to authorize sale of substantially all assets, free and clear of liens, claims, and interest?
Your Honor, I think it's earlier. If you look at the, just give me 1 second. I have the record appendix on my computer. If you look at the appendix and you go to record appendix page.
Start with 101, please, for me, because that's what I'm looking at.
Okay, because I'm looking at page 18, which has the decision in the decision in the record appendix.
Go to 101, please.
I'm going to 101, Your Honor.
So here's my question for you when you get there. Is this the operative notice of appeal for this case?
Give me 1 second, Justice Neyman. If I may, with your patience. In June of 22, Justice Sullivan authorized the sale for $700,000 plus things to come, things to be done. Then in February of 23, my brothers filed a motion to set the bond, presuming that the appeal was appropriately filed. In March, Judge Perino dismissed the appeal and set a $2 million bond. So it's confusing. If you look at the colloquy on pages 107 through 145 with the attorneys with Judge Perino, you will see that there's a confusing set of facts where even my brothers acceded to the fact that the appeal was appropriate. And in fact, one of the attorneys indicated to Judge Perino, this is a law school case. I've in fact talked to my professor, and it's very confusing. And then you see the colloquy, and Justice Perino says, well, the appeals court may have got it wrong. Of course, no judge of the Superior Court is going to tell you that you got it wrong. But he says maybe there's a suggestion that they dismissed the wrong case, and then it became a jumble of finger-pointing and who was wrong.
I share in your confusion, but the question remains because jurisdictionally, we need to know whether we are dealing here with an interlocutory appeal or an appeal from the final judgment. So my question remains, is what is at Record Appendix 101 the operative notice of appeal here?
This is the notice of appeal from July of 22. This is the notice of appeal interlocutorily from the decision of Judge Sullivan on June 15th for the authorization of the sale and wiping out, contrary to 111, 127I, the secured paper on the property. Sorry, Justice Neyman, I want to answer your question.
Okay. Well, is this the operative notice of appeal on the appeal presently before us?
I think it's one of them. I think that because
Was
it's
there
so...
a notice of appeal? I'm sorry to interrupt you. And this isn't an academic exercise. That's why I'm trying to get at this.
Justice Neyman, I want to satisfy you, please.
Well, was there a notice of appeal filed after the judge entered final judgment?
Yes, there was a notice of appeal, and it's in the docket. And if you look at it, it is, and I'm pointing your attention to the record appendix, and it was filed in April of 23. Record, just give me 1 second.
April 11th.
April 11th.
And that's where you notice an appeal from the order striking the appeal and then the excessive bond.
Correct, Your Honor. It's docket entry number 80.
Excuse me, not from the final judgment of March 28th.
Your Honor, the intent of the appeal was to appeal because it had been the second appeal and because Judge Perino caught us with a curveball where the motion was for setting in a bond amount, but all of a sudden it turned into a colloquy, as you can see over that date, March of 23, the hearing. I wasn't there. Of counsel, John Prettyman, who I work with, was there.
Do we have a copy of that notice of appeal in the record appendix anywhere in the record before us?
I believe that my brother submitted it, Your Honor, but it is a matter of record with the court, of course. What you can see, the first appeal was over the sale method, the amount. Then the bond came up, and then all of a sudden we got into a final judgment where the court, Judge Perino, said, well, according to him, the rest as you can read, and I'm quoting him, the rest as you can read is, here, I'm sorry. The court, okay, so I understand what happened. Okay, the single justice rules on the wrong notice of appeal, it appears. Your professor is correct. The professor that my brother's counsel is referring to the court is correct, because I'm looking at this and reading this, and the single justice says there's nothing here for EMCH LLC to appeal. I know an abuse of discretion, so I'm wondering where's that, ... The appeals court dismissed his appeal, perhaps erroneously, but that's all the Superior Court is, a dismissal of that appeal. It sounds like an appeal court issue. That's at the record appendix 134, 136. That's a colloquy before the court. So again, I share, I don't want to say confusion because that'd be too strong an adjective, but the concerns that we raise consistently and through the appeal process, the sale method, the price, wiping out the bonds, wiping out the secured mortgages, whether it was consistent with 111, 127I, because there's no language in that allows it. It allows for the receiver's liens to supersede. And my brothers say, well, it's only an issue because there are personal guarantees here, Justice Neyman. It's about $1,045,000, accumulated interest. And what my brothers say is, well, sue the bank if you don't think they acted in a commercially reasonable fashion. Well, that's an untenable position for us to take.
So on the bond issue, is your argument that there was no legal authority to set any bond, or is that, as I see it, I think your actual issue is that the imposition of a $2 million bond was punitive and not supported by the record? It's the latter, correct?
Justice Neyman, that is exactly and precisely our argument.
And our standard of review on that bond amount is abuse of discretion?
Correct.
Okay.
Correct.
Outside the
Again,
range of reason.
the argument was, it started at $400,000, it got raised up to $700,000.
Familiar with the facts.
Yeah. And what we're saying is, as Attorney Prettyman argument in that colloquy that you can read, look, it has to be, there's a number of cases, the Bank of New York Mellon versus King, the 2020 case that I cite, it has to be reasonably related to the sale price. I mean, at this point, my client and our position is, we would like our day of justice, and we're willing to pay a reasonable amount of a bond, because we cannot make the argument that no bond is necessary. That is not our argument.
Why is $2 million outside the range of reasonable alternatives as a matter of law?
Because there's no price set on the work to be done. There's promises, $700,000 in the agreement. It's a figure, it's discernible, it's quantifiable, it's in front of you in black and white. The work to be done, promised over a period of 2 years plus, subject to permitting, is ethereal in the sense.
What do you say to, and I apologize for interrupting, but what do you say to the receiver's argument that the environmental health and safety problems created by EMHC's neglect have existed at the park for more than a decade, and the costs necessary to address the historic problems are estimated to be approximately $2 million?
Your Honor, everyone in this case has thrown around numbers that are not subject to discernment by an expert engineer. I have spent a long time with my brother counsel in dealing with the Rent Control Board. The request for the receiver, and I'll get to your question, I swear, because I got 4 minutes, 37 seconds left. This started in 18 because there were issues associated with environmental. My clients built a packet plant, meaning an on-site waste disposal site. The park is old. It goes back from the 50s, and manufactured housing. The front is new, the back is old. In the back, the pipes leading to the packet plant are made of clay. They're not PVC, they're clay. So they were disintegrating as the park went on, and we had to move homes to do this. And then what happened was we had to pay pumping fees. So from 18 to 20, when ultimately we acceded to the receiver, my client was paying on the order of $30,000 in pumping fees, and it can no longer sustain that financial burden. But again, there's nothing in the record that says the park as it stands today is unhealthy. It hasn't been shut down by the Board of Health. It's continuing to be operated by the receiver, which I'm sure is not a pleasant task.
Why is the judge's finding that the repairs are costly, approximated at $2 million? Why is that clearly erroneous?
Because if you look at what's sustained or what supports that, it's an opinion in a purchase and sale agreement. There's no engineering attached to it. The purchase and sale says that, it's probably a couple of $1 million to do it. It's an assumption. Is it off the mark? Probably not. Probably on the order of what to do the work.
If it's probably not off the mark, then how can we say that the bond estimate is an abuse of discretion?
Because there's no confirmed agreement. The promise to do the work,
Why must there be a confirmed agreement? I'm not following that.
Your Honor, it's $700,000 with the promise to do this work.
I understand that.
Subject to partial to. There is no confirmed engineering report. There's nothing. It's a number. I could say it's $5 million. You could say it's $2 million. Do I think? I'm not capable of discerning what the number is. But the number that I see is $700,000 with the promise to do work. We're suggesting that a bond number, if applicable, would be $700,000 at least, but short of $2 million or subject to verification of the cost of doing the work.
Last question for me.
Yes,
Is
Justice
the
Neyman.
case to support that proposition, the New York Mellon case?
Yeah, I mean, it says it should reflect the sales price. The sales price here is $700,000 plus some work to be done, which is not supported by any expert's opinion other than the recitals in the agreement. I mean, the ultimate issue for us is the bond is one. We're prepared, if your justices set a reasonable bond amount, we're prepared to do that. But our concern is that under 111-127I, and I've read it over and over and over again, a lien from the receiver supersedes a secured mortgage transaction. But nowhere in that statute, in no case that I've read, does it allow the court to wipe out mortgages and security interest of record. And given the fact, and it's well stated in the record, that there are personal guarantees which go to the individuals who supported the acquisition of the park, and that's north of $1 million. And after the $700,000, after the receiver is paid, after the bank is paid, whatever's left, our assumption is, on good faith and the evidence in the record, that it wouldn't be enough and that there would be a claim of assessment against the individuals. And that would mean the question for the bank is, did you act in a commercially reasonable fashion? Because my brothers say the bank didn't raise an objection. They're okay with the deal. Well, we're not. Justices, I think I'll point your attention to my papers. If there's no other questions with 15 seconds left, I'll say good afternoon.
Thank you.
Thank you very much.
Mr. Morrissey.
Members of the panel, may it please the court. The premise of both decisions below by Judge Perino is that an appeal of the sale order imposes risk on the residents of the mobile home park. And it's the correct premises. It's the correct premise. The infrastructure at the park has been neglected and undercapitalized for years and years and years. The problems of this park go back to 2011, 2012. And absent a prompt sale of the park, there's a risk that the infrastructure will fail and the park becomes uninhabitable and the residents have to leave. The sale order that was appealed by the appellant was entered in June 2022. We're fast approaching the second anniversary of the sale order. I had a different presentation in mind, but I thought I'd react to Justice Neyman's concerns about the various notices of appeals that have been filed by the appellant.
You do have the notice of appeal.
I do. I have the notice of appeal.
April of 23 in your addendum. So let me ask you this.
There's a second notice of appeal, Your Honor.
And that's a second notice of it, but it's not of the judgment.
Correct. There was a final judgment entered, and that's attached to the appellant's addendum.
If there is no appeal of the final judgment, do we have jurisdiction to hear this case? Because that's where we need to start to make sure we can hear this case. Yes or no? Why not?
I don't think you have jurisdiction. There was an interlocutory appeal in June 2022 of the sale order. There was a second interlocutory appeal of Judge Perino's decision to strike the first interlocutory appeal and to require a bond in the amount of $2 million. No appeal, no notice of appeal, and no appeal was taken of the final judgment that Judge Perino entered following the hearing on the bond motion. Two notices of appeal on interlocutory matters, but no appeal of the final judgment. The time to take that appeal is run. I think there's no jurisdiction here.
So is that jurisdiction? Do we have discretion to hear it? Or are you saying, no, it's jurisdictional, we don't even have discretion? That's the preliminary question for the panel as far as I'm concerned.
We didn't brief it. Shame on us. My view is if you don't take an appeal of a final order, that's the end of it. The interlocutory appeals die when you fail to take a timely appeal of the final order.
Assume we do have jurisdiction. Where does the $2 million come from in terms of the bond amount? Why is it reasonable, and what in the record supports that? You have all my questions laid out at once. There you go.
You're going very fast, Judge. It's in the record. Let's start with the order appointing me on January 2nd, 2020. That's in the record, and that's I think in our addendum. I was required to post $1 million bond almost 3 years ago, more than 3 years ago. Second, if you look on the record, there was an affidavit submitted in opposition to the bond motion by Robert Morgan. Attached to the affidavit is a letter from the appellant's engineering company, Myers Engineering, that estimates the cost to repair just the sewage system, not the other systems, just the cost to repair the sewage systems was between $1.6 and $2 million.
I'm sorry to interrupt. Mr. Krause says, and writes in his brief, and he cites the Bank of Mellon case for this proposition, that the amount of the bond should reflect in some reasonable manner the sale price. You're talking about repairs. Do they go hand in hand, or is it something different?
I interrupted you. Let me explain. The sale price has two components. There's a cash component, $705,000, and plus an undertaking a heavily negotiated undertaking to bring the park into compliance with the health, safety, and welfare regulations including improving the infrastructure. That undertaking...
Without which it could never be ready for sale is the argument?
I don't understand your question.
Is the argument that without these repairs, the park could never be made ready for sale? In other words, does it go hand in hand with the, quote, sale price, or are you arguing this separate and apart from the sale price?
I insisted on a sale price that included an undertaking because my goal wasn't just to optimize the cash proceeds of the sale, but to bring the park into compliance with the health and safety regulations. And everybody who bid against this park had to take into account the neglected infrastructure and the undercapitalized infrastructure. And this is a common, I'm a receiver and I do a lot of bankruptcy, but I think the way we approached it in this case, and there's a case we cited in our brief, is very similar to what happens in housing court receiverships. Homes are sold in residential situations in the housing court where the buyer has to pay a purchase price plus stays within the jurisdiction of the housing court and bring the property into compliance with the sanitary code. And that was the genesis of our idea here. So our purchase price wasn't just cash. In fact, what I was focused on was coming up with a solution to the infrastructure. If the infrastructure fails, the park becomes uninhabitable. The attorney for the appellant pointed out that the appellant consented to the appointment order. If you look at the appointment order, there's a finding by Justice Green that the park is in immediate danger, immediate problems with respect to the health, safety, and welfare of the residents. Now, that was in 2020. We're now in March 2024. I think, and can continue to answer your question about where does the $2 million number, what support do you find that? If you go into Judge Green's memorandum opinion from 2019, she makes a finding with respect to the sewer system, that there was a bid for the sewer system of about approximately $1.6 million, and only $300,000 had been expended on the $1.6 million with respect to the sewer system. In addition, I've submitted not one but two affidavits, both in connection with the sale, the hearing to approve the sale, as well as the motion for the bond, where I've been the operator of this park. I've been acting as the owner of this park since 2020. I estimate between $1.5 and $3 million. What do I base that on? I base that on the bills that I pay on a frequent basis for the wastewater vendors and the wastewater engineers. I base it on the conversations I've had with interested buyers. I base it on conversations I've had with the homeowners association. When I took over the park in August 2020, the homeowners association told me that their estimate was they had a report from a consultant, Hogan. Their estimate was going to cost between $3 to $4 million to bring the park into compliance. All of this, I think, amply supports that Judge Perino correctly applied his discretion to come up with a $2 million penal amount.
And
the other thing he looked at...
You agree with Mr. Kraus that the standard of review on the amount of the bond is abuse of discretion?
I agree it's abuse of discretion. The other thing to point out, and I can't say this more strongly, is the underlying appeal, and this is something Judge Perino considered and Judge Sullivan considered in connection with the appellant's motion to reconsider in July 2022. The underlying appeal is meritless. The appellant had every incentive to bring an offer to me and to the court, more importantly, I'm an agent of the court as a receiver, a better cash offer than what was the result of our process. The appellant has brought nothing to me and nothing to the court, no competing offer, no broker, no competing transaction that's going to bring money into the estate and protect the residents at the park. Number two, on the record below, there's not even an appraisal from the appellant that says that, just looking at the cash component, that $705 is an insufficient price for this asset. Keep in mind, this asset has been subject to all sorts of regulatory orders going back to almost a decade.
No, we understand. Your argument is that this is a delay tactic. We follow that. I'm not saying we agree with that. I'm saying we follow that.
And let me close with some scary dates. I was appointed in 2020. The sale order entered in June 2022, where we've been able to get this buyer to extend, but the last extension is going to expire at the end of this month. If we lose this buyer, I don't know what's going to happen to this infrastructure, and if the infrastructure fails, I think it's going to be a catastrophe. So I don't think that the court below abuses discretion in setting the bond amount of $2 million. And as separate and apart from the failure of the appellant to appeal the final order, I don't think the judge made a mistake in striking the notice of appeal of the sale order, the interlocutory sale order. It's not on the grounds that the judge stated. I think there's this present execution exception to final orders when you're appealing a sale order from a receivership case. But when the appeal wasn't docketed, for whatever reason, the appeal wasn't docketed in connection with the sale order, the appellant did nothing. And I think the rules of this court, the decisions of this court say that something more is required from the appellate than following the express mandate of the rules and the express directives of the clerk. The appellant has a burden to move its appeal on, to advance its appeal. There's nothing on the record below that says that the appellant made a call to the clerk to find out why the appeal hadn't been docketed, or much less file a motion. And that's why we filed that bond motion.
Final question from me, which is, under what authority did the judge set the bond?
Equitable authority.
Authority.
It's an equitable case.
Seeing no further questions, thank you. Thank you both. We'll take it under advisement.
Thank you, Your Honor.
With that, I'll bring to a close our session today. I'd like to thank our clerk's office, our court officers, my colleagues, and the law clerks, and our